today we're going to have someone who's speaking to you who's known to many of you, I'm sure. He's currently Vice President of the Royal Historical Society of Queensland, but he's not here in that role. He's here in the role of a retired Barrister-at Law, retired Magistrate, Coroner, and various other legal terms, offices he's occupying. Someone who, in fact, has played a significant role in legal aspects of Queensland over his time, and he's still very, very active. So would you please give a very big welcome to our speaker today to talk on Sir Samuel Griffith, the writing of Queensland's Criminal Code. Would you please welcome Michael Halliday.
Thank you, Denver, for those kind words, and welcome everyone. I've been told in passing that this lecture is going to whet your appetite, we hope, for a function that we're having shortly, which Denver will no doubt talk about later on, and that's going to be the Griffith Conference to be held on Saturday the 20th of February. Although I think it might be pretty much booked out, but we never know with the... it's not.
It was started with the increase in numbers.
Well, we hope that the numbers might be thrown open a little further, but time will tell on that. In the preparation of this talk, I acknowledge the great assistance that I have gained from several scholarly papers prepared by that great Queensland jurist and academic, Dr. Robin O'Regan, AM, QC. On the 1st of January 1961, the Criminal Code of Queensland, drafted by Sir Samuel Griffith, came into force in Queensland. The code was drafted unassisted by him in his spare time as Chief Justice over a period of some 5 years between 1896 and 1900. It was the first criminal code to be drafted and enacted in Australia, and as we'll see during the course of my talk, has served as a model for criminal codes in other Australian jurisdictions and in many countries throughout the common law world. Denver Beanland, in his then capacity as Attorney General and Minister for Justice in 1998, said this about Sir Griffith. Sir Samuel belonged to an age in which a person could fully explore their diverse interests and make a significant contribution in not one, but many fields. Through his great talents as a barrister, politician, legislative drafter, statesman and jurist, Sir Samuel contributed both to the development of the state of Queensland and to the Commonwealth of Australia. Griffith has been further variously acclaimed, including by the Chief Justice de Jersey. He was a man, a jurist of towering intellect, a judge of massive achievement. And T.J. Ryan, then Premier on the occasion of Griffith's retirement from the High Court, said, "He was a great statesman, a great lawyer, a great judge and a great scholar, but he was a man of unimpeachable integrity, of single-minded purpose and burning patriotism. No one could have believed more firmly than he did in the gospel of hard work, or have made it more completely a guiding principle of his life." The Criminal Code was said by his biographer Roger Joyce to be Griffith's major but not his only contribution to law reform. Accordingly, the object of my talk this afternoon, although Griffith's achievements were many, the object will be to briefly examine the circumstances giving rise to the development of the Criminal Code, its historical development and its evolutionary influence upon Australian and international criminal jurisprudence. Separation from the colony of New South Wales, 16th of June 1859, brought the common law of England to the colony of Queensland. The Supreme Court of Moreton Bay previously no more than a branch of the New South Wales Supreme Court, was now sitting in Brisbane, and it became the Supreme Court of Queensland. I want to address a notion attributable to Lord Denning concerning the Great English Oath. His Lordship said the common law cannot be applied in foreign lands without considerable qualification, just as with the English Oath. So with the English common law. You cannot transplant it to an Australian continent and expect it to retain its tough character which it has in England. It will flourish, indeed, but it needs careful tending. So with the common law. It has many principles of manifest justice and good sense, which can be applied with advantage to peoples of every race and colour, all over the world. But it has also many refinements, subtleties and technicalities, which are not suited to other folk. Those offshoots must be cut away. My talk is going to visit the pruning of the English criminal common law, Oath, by Sir Samuel Griffith, so as to suit Queensland conditions, resulting in the evolution of the Queensland Criminal Code. By way of brief background, Griffith the man was born in Wales in 1845 and arrived in Queensland at the age of 18 in 1854. He entered the University of Sydney aged 15, where he obtained first-class honours in classics, mathematics and natural sciences. He obtained articles of clerkship to an Ipswich solicitor. His legal studies, however, were interrupted when he took up the highly competitive Mort Travelling Scholarship granted by the University of Sydney in order for him to visit Europe and England. I mention that because it was on that journey that he commenced to learn Italian, which subsequently enabled him, when he had sufficient time, to translate Dante's Divine Comedy. And it also assisted him in his appreciation of the Italian Criminal Code, which he had regard to in the drafting of the Queensland Code. He was astute enough to make application to the Supreme Court to have deemed such absence from his articles to be treated as not a breach of his apprenticeship. That leave was granted. On his return, he was admitted to practice as a barrister without having to make up any additional time. He was admitted in 1867. I'm going to miss out. I don't want to talk about his great political career, because that's going to be dealt with at the conference that is going to be held in a couple of weeks' time. I'm going to jump straight to his appointment as Chief Justice. He was appointed Chief Justice of Queensland in 1893. And soon after his appointment, he was requested by the then Premier, Sir Thomas McIlwraith, to undertake the preparation of a draft code of criminal law for the colony. A task he performed, as I indicated, unassisted, and he did so in what was referred to as his spare time as Chief Justice, and it resulted in a document containing some 733 sections. Deakin remarked in wonderment how Griffith had found, quote, leisure for such a feat whilst discharging the onerous duties of his office, end of quote. Well, what is codification and why was it needed? Codification has been defined as the setting out in one statute or one document of all the law, not only dribs and drabs, but all of the law relevant to the particular topic, whether it be found in statutes or in common law. In essence, the code contained the criminal law set out in one concise document, a volume, instead of being contained in numerous sources requiring substantial research in law libraries and government archives. Griffith himself envisaged that the code should be a collected and explicit statement of the criminal law in a form that could be ascertained by an intelligent person. While pointing out to the Attorney General in his well-known explanatory letter, which was forwarded with the draft copy of the code, that the criminal law of Queensland at that stage was scattered throughout nearly 250 statutes outside of the applicable principles of the common law. Why was codification needed? I refer to what has been mentioned as the English dog's law of the common law in England. The reference to dog's law being that a dog is punished for something that he doesn't know that he can't do, and he only learns that what he's done is wrong when he's punished. The average Englishman did not know what the law was, couldn't find it. And some of the English judges, it said, didn't know much about it either. There were certain deficiencies in the English criminal legal system, and those have been particularly identified by Jeremy Bentham, legal academic and the campaigner for legal reform. These included difficulty in ascertaining the relevant legal principles and relevant statutory provisions, together with much criticism of the harshness of the punishments being meted out to people. Following a campaign calling for rationality within the law and deterrence against offending, it was recommended by Bentham that there ought to be developed a code of rational and humane system of law and penalty. Such a campaign, although active, proved unsuccessful in England, despite attempts to introduce a code of criminal law in that country, drafted by Sir James Stevens in 1878, with a further edition in 1879 and eventually in 1886. The document was introduced into the House of Commons but was never enacted. However, such concept found support initially in the colony of Queensland, subsequently other Australian territories, and a bit like the cane toad, I suppose, spread throughout the world, as we will see later. Now, the task facing Griffith was mammoth. Firstly, he had to ascertain what the criminal law was, both the common law and the statute law, that was then relevant to the colony of Queensland. As at settlement in 1788, according to the English common law, as it expressed and opponed by Blackstone, such, quote, settlers from the mother country carry with them, like in their hip pocket, so much of the English law, common law and statute law, as was applicable to their new situation and the condition of the infant colony. Further, the task facing Griffith involved a consideration of not only the Queensland Acts, but also of the New South Wales and English Acts, which applied to Queensland prior to separation and until repealed. Further, English statutes which had applied in New South Wales under the Australian Courts Act of 1828. Further, the common law before 1828, which was imported, if applicable, to the conditions existing in the colony of New South Wales and Van Diemen's Land for the period 1788, that's the date of settlement, to 1828, the date of the Act. If that wasn't enough, the second task that Griffith had to undertake was to discover and to consider what other possible offences might be introduced and relevant to the new colony. He also wanted to work out a statement of the principles of criminal responsibility. We're going to have a look at that later on if we've got time. Further, he had to ascertain legislation passed and relevant, but which ought to be repealed, having regard to it not being relevant any further to the new colony. And finally, almost finally, the drafting of relevant rules and procedures to put the new code into effect. most importantly, and finally, he had the task of attempting to set out in the code all possible defences to criminal offences. Now, Stephen and his commissioners in England had failed to do that, merely saying or saving the common law defences to the extent that they were not inconsistent with other provisions of their then suggested code. So, the research that Griffith undertook included using a skillful blend of ideas developed from a range of sources. He examined the draft criminal bill of 1880 of Sir James Stephens and his commissioners, to which I've just referred, the Italian or the Zanardelli Penal Code of 1888, a most important document, one which he was able to appreciate because of his newly acquired knowledge of the Italian language, and which provisions, in particular section 23 of the Criminal Code, was transposed or adopted. The Penal Code of New York of 1881, which he followed to a certain extent and adopted certain of its provisions, together with other continental codes. In October of 1897, Griffith forwarded his draft code to the Attorney General, accompanied by a letter dated the 29th of October, in which he offered some general comments about the code, the material and the authorities to which he had referred, together with a general outline of its structure. I'm not going to refer to the letter, you can read that for yourselves. Upon receipt of that document, a Royal Commission was appointed on the 15th of December 1898. The Royal Commission was appointed, directing the commissioners to examine this document, to examine the draft document, and to make recommendations to the government, including, firstly, the expedience of having a code and to enact a code. Secondly, the completeness of it, whether it had gone far enough or whether it ought to be further amended in draft form. To consider the proposed changes and the effect it would have on the existing law, and any additional omissions or alterations that the commissioners in their wisdom thought expedient to bring to the notice of the government. Well, who constituted this Royal Commission? Well, funny enough, Griffith was appointed chair. Good idea, I suppose. And a number of other judges of the court, as well as the Attorney General. Good to have the attorney there to keep an eye on things. The Crown Solicitor, Crown Prosecutors, most important to have the Crown Prosecutors involved, because they're going to be told what they have to be doing and what the law is and what they have to prosecute, together with other senior lawyers from the court. Now, the Commission met on 26 occasions and submitted its report with a draft bill attached to it. That was done on the 1st of June 1899, recommending the adoption of the draft after some relatively minor revisions. It appears from the report that there was a division that couldn't be resolved unanimously by the Commission. And this was in relation to two matters, and apparently two matters only. Firstly, the punishment for rape. A majority of the commissioners proposed that rape be no longer a capital offence. But Griffith and Justice Chubb disagreed, asserting, quote, "The circumstances of some parts of the colony do not yet warrant that charge." Says something for our early settlers. Secondly, the innovative provision making provocation an absolute defence to a charge of assault. One would have thought that would have been a normal type of defence, but not so at common law. Griffith was among the majority who favoured that change. Other proposed amendments included, firstly, substitution of life imprisonment for the death penalty for robbery under arms, the extension of Griffith's merciful provision for conditional suspension of punishment of first offenders in certain circumstances to all offenders. And the bill came before the Legislative Assembly in September of 1899. There was some lively debate concerning the draconian penalties for capital punishment. Concerning, firstly, imprisonment in irons. The order could be made that prisoner serve a period of imprisonment, such to be served in irons, typical of the old convict days. Secondly, solitary confinement. And thirdly, whipping, which under the code, under the proposed code, as under the then law, could be imposed for various offences. If I might jump forward a little to more recent times, capital punishment in Queensland, as you will remember, was abolished in 1922. Solitary confinement as a punishment and whipping only as recently as 1986. The Attorney General successfully resisted moves to delete all of these draconian penalties, except imprisonment in irons, a punishment which could be imposed for offences of violence. Recommendations that were made proposing the abolition of the death penalty for rape and robbery under arms were accepted, leaving only 3 capital offences: murder, treason and piracy. It's interesting to note, by way of aside, that neither the draft bill, or neither the bill nor Griffith's draft code followed the lead of the Indian Penal Code, which had already abolished capital punishment completely. It's interesting to note the provisions that were made in relation to first offenders and probation. Griffith proposed that there be conditional suspension of punishment of first offenders, a radical approach. That was adopted. This was a radical reform for its time, based as it was upon an earlier Queensland Act, the Offenders Probation Act of 1886, which Griffith himself had sponsored when Premier, and which had established the first statutory scheme of probation in Australia, and one of the first in the common law world, and which became the model for the original probation statutes in all of the other Australian colonies. It's interesting further that Griffith insisted that prisons made criminals out of relatively innocent and usually young offenders. Pick up the paper this morning and you see what Queensland's proposing in relation to our unfortunate young offenders. Lock them up. Something Griffith didn't approve of. The clauses of the bill relating to substantive criminal law, however, as distinct from penalties, were debated less vigorously and were approved with only slight alteration. The bill passed through Parliament in October under the title of the Criminal Code Act of 1899. Well, Griffith wasn't finished yet. bill had been passed, so what did he have to do? He had to get back to his writing board again, and he had to prepare the criminal practice rules, the rules that were to be applied to put that act into force, which he did. He drafted those in 1900. He still wasn't finished. The bill had to be passed in the sense of receiving the royal assent. And guess what? Griffiths at that time was the acting governor. So the bill came before him on the 28th of November, 1899. What a great method to put a seal of approval on your work when he's signed that document. A seal of approval for his own handiwork, in which he did. And the bill came into effect under that name of and together with the rules on the 1st of January 1900. Well, what were the important matters contained within that bill, or in the code, which were different from the common law? What are those matters that stick out? The most important principle, I believe, in my view, was the removal of the common law requirement of a guilty mind for the commission of an offence, before a conviction can be imposed. It was an important principle of the common law that a person may not be criminally responsible for an offence unless the prohibited conduct was accompanied by a guilty mind. Under the Criminal Code, responsibility does not depend on that doctrine of mens rea, but rather on the specific provisions of the code relating to the particular offence. And later on, if we've got time, I'm going to give you an example of what the code looks like and how it's set out and how one interprets it, etc. And the common sense approach behind it. As Griffith himself said, as, jumping ahead again, Chief Justice of the High Court. What happens? He's gets appointed to the High Court, and one of the first cases that comes before him, interpretation of the Queensland Criminal Code. The ink's probably still wet on the royal assent. That comes before the High Court. And he said, in the case of the Widgie Council and Bonnie in 1907, he said, under the criminal law of Queensland as defined in the Criminal Code, well, he'd know what it said, it is never necessary to have recourse to the old doctrine of mens rea, the exact meaning of which has been the subject of much discussion. Well, that's the old common law rule, and many common law judges really didn't know. There was a diverse opinion as to what it meant and how it was to be applied. Further, Mr. Justice Philp, some years later, said, Mr. Justice Philp of the Supreme Court of Queensland, in Queensland, in determining criminal responsibility, that is, whether a person is guilty or not, the court is not riding the unruly horse of a moral doctrine. It is mounted on the steadier steed of a statutory enactment. So, the unruly horse of the common law was not going to prevail any longer in Queensland. The Criminal Code contains all relevant defences to all offences. It's no good defendants coming before the court and saying, I'm not guilty because Magna Carta says I'm not. Happens all the time in the Queensland courts and in other courts. Look up the code. Magna Carta mentioned? No Magna Carta. Out the window with Magna Carta. The important provision is section 23 of the Criminal Code. These words should resound in the minds of every prosecutor, every defence counsel, and every judge, and the jury should be reminded of it. Clear, simple words. That's what Griffith liked. Simple words to be understood by an intelligent person. The words I will read to you. A person is not criminally responsible for an act or omission, that is something that you have done or something you failed to do, which occurs independently of the exercise of his will. Very simple. There's a few more words I'll come to in a moment. The act or the omission that causes the injury or causes the event must occur independently of the exercise of his will, or for an act which occurs by accident. So, you must have a willed act, so to speak, and you must, or if it occurs by accident. So, if you're chopping the wood, for example, as happened many times in the old days, chopping a block of wood, and a piece of wood that you're chopping flies up and hits somebody. Is that a willed act? Is that an act that occurred independently of the exercise of your will? Or is it an accident? That's the most important division of the code, in my view. The other relevant matter was that homicide was divided into categories. Of murder and manslaughter. That's another important distinction from the common law. There was a broad definition given to insanity. The English common law subsequently became caught up with what was known as the McNaughton rules regarding insanity. There was a broad definition given by in the code to insanity. I'm not going to go into what these are, I'll be here for months, but there's something for you to read about when you've got a spare moment. The next difference was the defence of provocation in cases of murder, which was different from the position in common law. And finally, the defence of provocation to assaults. That was a new defence. In addition to that, the code was not confined solely to criminal law. Griffiths very shrewdly incorporated in the code the law relating to defamation, stuck it in there. And what he did was that he incorporated in the code the Defamation Act of 1889, and it clearly abolished the distinction which he considered to be archaic between slander and libel. Difficulties arose in the interpretation of the common law prior to the introduction of the code. You had to find out what it was first of all, where you would have found it, what did it mean, and there were various differing opinions in the judiciary about it. Similar problems did not occur with the code to such a degree. the test has been variously expressed, but in the case of the Queen and Jarvis, Acting Chief Justice McPherson laid down this test, which I suggest is the appropriate one, which was accepted by the Court of Criminal Appeal. In applying the provisions of the Code affecting criminal responsibility, our first and our last loyalty is to the words of the Code itself. You look at the words of the Code, they're simple words, simple English words. However, His Honour then went on to say that this did not reduce the task of contrasting the Code to a mere mechanical exercise. He said, in his view, it was permissible and instructive to seek guidance from interpretive decisions on the issue in question in other jurisdictions where the Code, where Griffith's Code or some antecedent or derivative of it applied. So I'll come shortly to the other places where the Code applied, and if there's a case on in that jurisdiction as to what was meant by a certain word, have a look at to see whether you agree with that and whether that is the meaning you want to give to this simple English word in the Code. He did say, however, he went on to say that it would be permissive to consult, at least for the limited purposes of the common law, in order to ascertain, quote, practical illustrations of particular problems and the approach of the common law that was made in solving it. Now, I indicated right at the very beginning that the Code has been adopted in other jurisdictions. And I'm going to refer to those now. The Code has served as a model for criminal codes in other Australian jurisdictions and in many countries throughout the common law world. And I'll just refer to those now. I hope you can see these. I'll read them out to you anyway, so that you... Well, that's a younger version of Griffith. I might, as an aside, say that when he was on his tour of Europe as a young fellow, he rather liked the young ladies, and especially his cousins in England. And for those of you who would like to read some of that in his biography, there's some examples there of the tricks that he used to get up to on the continent. Yeah. And he also apparently liked the occasional drink too. And so it makes fascinating reading. Anyway, he came back to Australia and he was a reformed young fellow and soon, as I've indicated, finished his studies, etc. That's not as a quiet a young fellow, but in his young years now. Now, this is the Criminal Code. It starts off in Queensland in 1901. And it then goes to Western Australia in 1902. Goes to Tasmania in 1897. With a draft there in 1924, and then it goes eventually to the Northern Territory in 1983. A leading member of the Queensland Bar, Mr. Des Sturgis, who was the director public prosecutions had a very important role part in redrafting parts of the code to make it more applicable to the Northern Territory and to update it to suit their terms and conditions. It went to British New Guinea, later Papua, now part of Papua New Guinea, 1903. Went to New Guinea, now part of Papua New Guinea, 1921. Northern Nigeria, Bermuda, New Guinea, I mentioned that, went to Cyprus. Kenya, Uganda, the Gambia, Northern Rhodesia, Zambia, Tanzania, Malawi, Palestine, the mandated territory of Palestine, Zanzibar, the Seychelles, Fiji, the British Solomon Islands, Botswana, etc. So you can see how it's really spread across the world in the common law countries. Now, if you pick up one of those codes, for example, I had a look at the code from Bermuda. It's almost in similar words to our code, but it's been slightly changed to suit the local conditions, etc. Section 23, it looks as if they've just taken it straight out. It's almost the same. All right. I just want you, this isn't intended to be a legal lecture, but what I intend to do now is to show you an extract of the Criminal Code and to try to convince you how simple it is and how easy it is to understand, and the logic that was in the mind of Griffith as he was drafting it, keeping in mind that the whole point of the document is for an intelligent person conversant in the English language is able to understand simple words and simple concepts. All right. That's the Criminal Code, that's the cover of the... And I'm going to refer to what we know as murder. Well, it starts off with the simple proposition, well, killing of a human being, unlawful. That's the head, that's the title. Well, we all know that. It's not just go out and kill someone. It says it's unlawful to kill any person unless such killing is authorised or justified or excused by law. So, you can see straight away that you've got the general principle and you've got some exceptions there by way of defences. Now the issue is, the first issue that you'd want to know is, well, what's a human being? That would be a common thing to know. When does a person become a human being? So it says a child becomes a human being capable of being killed when it has completely proceeded in a living state from the body of its mother, etc. Now, to stop any argument about, well, at what stage does the child have to be breathing or what have you, etc., Griffith goes on to say whether it's breathed or not and whether it has independent circulation or not and whether the navel string is settled or not. You can see, therefore, that some of the common law arguments that have been, it might be abolished, that some doctor might say, oh, but a person isn't a human being because it hasn't been severed from its mother. Well, it's not a human being because we don't know whether it breathed or not. So Griffith said, look, this is nonsense, or hit it on the head. This is what common sense is. No argument. All right. Well, what's meant by killing? That's another thing. So he goes on to say, except as hereinafter contained, any person who causes the death of another, directly or indirectly by any means whatever, is deemed to have killed that other person. Then it goes on to say that any person who unlawfully kills another is guilty of a crime which is either called murder or manslaughter, depending on the circumstances of the case. All right. Then it defines what murder is, because we know that if you do have an unlawful killing, that's divided into either murder or manslaughter. So what's murder? A person who unlawfully kills kills another under any of the following circumstances. That is to say, if the offender, first of all, by the way, I haven't set out all the circumstances. These are the more important ones. If the offender intends to cause the death of the person killed or that of some other person, or if the offender intends to do to the person killed or to some other person some grievous bodily harm. Or if death is caused by means of an act done in the prosecution of unlawful purpose which act is of such nature as to be likely to endanger human life. That's, for example, an example might that be where you go into a bank to hold up the bank, and in the course of that, the gun goes off. Your mate there who's a lookout, for example, he can also be charged under this particular, because you've got the unlawful common purpose. All right, then we go on to the definition of manslaughter. A person who unlawfully kills another under such circumstances as not to constitute murder is guilty of manslaughter. Well, that brings my talk to an end, and I see I've really gone well over time, I think, but I hope that when you leave here that you might say to yourself, well, I've learned something a little bit about the criminal code and the part that Griffith